Hi, everyone. Welcome to Data People's webinar on Hiring Compliance 101. All the questions you had about compliance and hiring, but didn't know who to ask. Today, my name is Amit Bhatia. I'm the co-founder and CEO of Data People, a compliance and standardization platform for recruiting. And today I'm joined by Renee Jackson, who has been a head of HR and an Employment Counsel, and currently runs Blue Oak Legal, an employment law firm helping companies and startups all over the country. Renee, thank you for joining us.
Thanks
Tell
for
us
having
more
me.
about what you've been doing.
Sure. So thank you for having me. Looking forward to our chat. So I started Blue Oak Legal almost coming up on a year. And I work with a lot of small SaaS companies like Data People, helping them with employment law compliance, but also commercial contracting, product compliance, lots of different things. It's a really fun space to work in because I get to work with small startups and kind of see things from the beginning and hopefully see that growth pattern. So very, very excited to be here.
And Renee, you've also been an HR executive. So you've seen both sides of this as both counsel, but also as somebody in charge of the people function, in charge of the recruiting function. How have you sort of seen, how did you, as well as how have you seen your customers react to the massive change in the regulatory framework surrounding hiring in the last few years?
It's hard. So I have had that dual hat role where I act as, both counsel for the company and head of HR, managing the, recruiting function, HR ops, et cetera. And, oftentimes we're looking for an ATS solution that helps with compliance because there are so many things to, make sure that you're following and keeping track of and complying with. And so oftentimes I look to an ATS solution or solution like Data People to help, when you're a small company, super scrappy, you don't have a huge team, you don't have a dedicated resource who can, just do this day in and day out. I really look to kind of tech resources to help with compliance because there's so much to think about.
No, that makes a ton of sense. And there is so much to think about. It's like, especially post the pandemic, every jurisdiction is different. We're all hiring in a distributed world, and we're trying to make sense of local laws where in the past, perhaps we only dealt with, laws in one jurisdiction, laws in one specific. And so we're in a very dynamic world. And that must put a lot of
Absolutely.
pressure on HR folks.
There was a time where you could say, if you're a national employer, a large national employer in the US, you could say, you know what, we're just going to comply with California law. And because it's the most strict and has the most requirements from an employment perspective. But those days are coming to an end, I think, because you're seeing other states like New York, Massachusetts, and even Colorado really leading the way in some of these new laws. And so you can no longer just say, all right, I'll comply with California and hope for the best. You really need to be following very closely all of these new legal developments, especially in AI and some other, tech connections.
I really feel for talent acquisition and HR professionals these days. Like they have to do their job, they have to be data scientists, now they have to be lawyers. Like how much can we ask them to be? But you don't have to be lawyers. You can access great lawyers like Renee or access platforms that help you comply like data.
And I think that a lot, TA folks are really smart. There's a lot of smart TA recruiters and managers out there. And I think if you kind of explain this like we're going to do today, which is why is this here? Why does this happen? Give them the context and kind of demystify, some of these laws and some of these legal requirements. I think a lot of it does come down to common sense and transparency. And so the
That's
more
right.
you can educate TA and HR, even HR ops, because they do have a big role in a lot of these functions and following these laws that we're going to talk about, I think that goes a long way for any organization.
That's right. Well, with that, let's get right to it.
Let's do it.
So the first thing, one of the things that's the hardest, 87% of employees said that they were in situations where they didn't know how to comply with law. And certainly in TA, this is a very pervasive problem because TA historically has not been a, a function that has had compliance be a major part of it. That always was a part of HR, but not a part of talent acquisition. But post-pandemic in a distributed world, that changed. And then on top of that, we're living in a world where we're starting to get AI regulation, we're starting to get this privacy regulation, all of which starting to affect talent acquisition in meaningful ways. And so we're starting to build that. And before we jump into the individual regulations, we want to talk about what is the regulatory framework just in the US that you should be aware of. And there's so many. There's the ADA, ADEA, the EO regulation. And even beyond this, if you're a government contractor, you care about OFCCP regulation and being compliant with that. If you're an international, you're worried about GDPR. You're also worried about other Europe has its own AI regulation. So there's a whole range of different regulatory frameworks to worry about. Renee, as you think about this landscape, and especially as evolving as it is, what stresses out HR and TA people the most?
All of this, but I think probably from a administrative perspective and from a legal risk perspective, it's probably the wage and hour laws. So the FLSA and state equivalents and even now more pay transparency, because there's a lot that goes into making sure you're complying with wage hour laws and pay transparency, disclosures, etc. And if you get those wrong, those, especially the FLSA classification issues, those are the big ticket, legal risks where you can get up in the millions of dollars really fast. If you get, especially if you're a large organization and you get a classification wrong, you're looking at a class action. You're looking at a lot of big costs to defend and potentially settle or litigate claims of misclassification. So that's what keeps me up at night. And so I think in the HR world, when you're thinking about legal issues, oftentimes it's the FLSA stuff, those big class actions with the big dollar amounts.
And one of the things that's so dynamic, unfortunately, is that these are not always federal regulations, right? So especially pay transparency is something that's created a lot of stress for talent acquisition professionals everywhere because it's defined state by state, sometimes city by city.
Yep.
So New York City has its own pay transparency law that's slightly different from New York State. Washington State has a very specific type of pay transparency law. And then it starts to crop up. So Hawaii released it recently. Illinois is scheduled to roll out later this year. And then you have this even in international geographies, specific jurisdictions in Canada, specific jurisdictions in Europe. And it becomes hard to kind of keep it in mind, especially when you're hiring remotely, because some of those remote jobs may or may not be subject to some of the different local jurisdictions. It's so hard, but let's dive into each one of these. But before we do, let's talk a little bit about the job post itself.
Mm-hmm.
Now, a company doesn't need to have a job post, although almost every company does, because it's hard to get candidates and applications and all of those things if you don't tell people what the job is about. We live in a world where people are mostly applying online to jobs and we're using them as marketing documents. But I think one of the things that's gotten really complicated is the blend, because this is not, once you have it, it's not only a marketing document, but it's also a legal document. And so how do you manage both of those constituents in it with the right level of care and responsibility?
Yeah, it's a good question. I mean, ultimately, the job post is there to set expectations with candidates. This is the role, this is the company, here's the type of person we're looking for. But there's also, a component that is legal in nature, where employers either have to put certain things in the job description or want to put certain things in the job description to cover themselves from a legal perspective for something that might happen down the road. And so some of it's reactive, some of it's proactive, and you do end up with a mix of, a job post that's rah, rah, here's the company, here's the job, we're so excited, please apply. And then, at the end, there can be some pretty heavy legalese and links to privacy policies and things like that. And so, I think you just need to get the mix of that right. And there are ways to, comply with the law that don't have to be super formal. We'll talk about EEO statements and things like that. And, just because everyone is putting this very formal EEO statement on their job post doesn't mean you have to. I mean, it's a branding opportunity. You can draft that yourself as long as you cover some of the major points. And so it is a hybrid document. But I think most importantly, it's to get people in the door, first and foremost.
And a lot of it comes down to just having really good processes and standardization and templates.
Yes.
Because then this is where companies go wrong. It's one thing to have the world's most expensive legal counsel telling you about all of the risks. But if you don't codify and standardize the way you put this into your job post, it doesn't matter because you're still going to be exposed.
Yes.
And where we see companies make mistakes is they go way too far in one direction or the other. So either you have no regard for some of the compliance elements, you're sort of, ask for forgiveness, not ask for permission sort of mindset. And that's risky, especially as you become a public company, as you become a larger organization, even beyond just the regulatory risk. Every time a company gets a lawsuit or gets fined, there's an employer brand risk that comes with it. There's the press and all of those pieces that you just don't want to avoid. But then we also see the other end where you're trying to be so safe and you put so much boilerplate language in a world where candidates are reading a job online, on LinkedIn or on their phone sometimes with falling attention spans, and they just start reading your job because they're like 3 times the length of every other job in the market. And nobody wants to read terms and conditions to figure out if you want to get a job or not. It's not.
No. You don't want to click on the employer's terms of service just to, in order to apply for the job.
But sometimes you're reading a job and you feel like, my God, like did I accidentally click on like Apple's like new software update?
Exactly.
And so we gotta find that balance. And that's what we're here today to talk about the risks, the rewards, and help you identify the framework with which you can make some of these decisions.
Yep.
Before we jump into that, I wanted to just describe the difference between a job description and a job post, because sometimes we get them conflated. Job description is often that internal compliance document. It's a very long document where you want to be as verbose as possible about the requirements, the responsibilities of a job. It may not have things like an advertisement about the benefits you offer. It may not have verbose, verbiage about the company and why it has amazing culture. It's not a marketing document, and it's often controlled by human resource professionals. There's often job architecture teams or job architecture programs that sort of think about this. And then you've got the job post, which very much is a marketing document. It still has compliance elements, but it's succinct. You don't have to list every requirement or every skill. You don't have to, or every responsibility, but it needs to have information about the company, about the role, about the team, about the benefits. And so it has both more and less, but it's written for a different audience in a different purpose. And today we've got to talk about how you think about compliance for both of these documents, but especially around job posts, because those are the ones that go out into the world and therefore create potential risk for organizations that are writing jobs.
Yeah, and just 2 comments on job post versus job description. One is, at a lot of companies, the job post becomes the job description because they don't have a huge HR department that's doing job family architectures or any of these behind the scenes leveling exercises. And then on the flip side, there are companies who have both the job post and the job description, but they don't match, right? So, you really, if you have both, you want to make sure the essential functions, in the formal job description are the same ones that you're listing on the job post. And so, if you go down that road where you're creating 2 separate ones, make sure that they align because otherwise you're not setting proper expectations with that candidate or that employee. And, it may lead to confusion or even legal issues that we'll talk about a little bit.
That's right. So with that, let's get right into it. Let's start. We're going to go through some of the big regulations that you should be thinking about as an HR practitioner or a TA practitioner. Let's start with the American with Disabilities Act. Renee, tell us a little bit about how this applies to job posts and job description.
Sure. So the ADA prohibits employment discrimination against qualified persons with disabilities. And, that's a very broad statement, but from a practical perspective, what it means in the hiring context is employers are required to provide reasonable accommodations to candidates and employees during employment, unless doing so would cause an undue hardship to the company. A really good example of a reasonable accommodation during the hiring process is someone needs some sort of translator, and not a language translator, but they could have hearing issues, and they need to be able to type their responses to interview questions rather than having a video call, or all sorts of things like that come up during the hiring process where you have a qualified candidate. They want to apply and interview for your role, but maybe there's something about a disability that they have that they can't go through the normal process, and so they need some sort of accommodation in order to be able to participate. And employers are required to kind of accommodate those candidates as long as there's no undue hardship on the company. So in the example of someone who has hearing issues and they want to type, have basically almost like a chat interview, that in most cases would be reasonable. I can't think of a reason why that would be an undue hardship on the company to provide that type of accommodation. So that's one of the obligations of the ADA. How this comes into play in the job description or the job post is you'll see a list. It may not have a headline that says essential functions, but it'll say, what you're expected to do, or, responsibilities of the role, or something like that. And what that is it lists out, everything that's the primary responsibility for this role. Here's what we need you to be able to do. And then sometimes you'll see nice to haves, like need to have, nice to have. Those need to haves are, what basically are the essential functions. And obviously you're putting that in the job post to set expectations with the candidate of here's what we need you to do. Please apply if you think you can help us with these things. But another way it comes into play is down the road, after you've hired this candidate, they become your employee. Those essential functions still apply to their role, but they may become disabled or they may disclose a disability. And then you have to go through that same analysis with them as an employee, where they ask for an accommodation to, basically enable them to perform the essential functions of the job. And you, as the employer, have to figure out, is it a reasonable accommodation? Is there an undue burden on us in order to be able to give the employee that accommodation? And so really what you're doing with the job post is setting the stage for a reasonable accommodation interactive process that may come into play down the road. And the same goes with physical demands. You don't see these a lot, in tech companies like yours. It's not this isn't a warehouse that someone's working in, but when you have roles that require physical components, like you need to be able to operate a forklift, or move a pallet, or carry an item weighing 25 pounds from here to there, you'll see physical demands listed in the job description or the job post. And again, it's to set expectations with the candidate, but it's also setting the stage for, if that employee down the road, once they become your employee, can't do, the lifting 25 pounds on their own by carrying it themselves, a reasonable accommodation may be that you, I don't know, get them a robot that can do the carrying of the 25 pounds for them, or something like that,
or a forklift, or any number of sort of automated.
And so really, when you see these things in the job post, it's being transparent
Yeah.
with the candidate, but also setting the stage for down the road if
So,
this ever comes into play.
and while we think about the ADA as often being associated with jobs that have physical demands, the ability to lift things, the ability to move around, increasingly, and therefore you think, oh, this applies primarily to sort of factory roles or warehouse roles. Increasingly, we're, companies are rethinking their relationship with this statement, and broadening the definition here, whether or not it's strictly required by the ADA, yet it tends to catch up. Increasingly, tech companies are thinking about how they can be more accessible to candidates who are on the neurodivergent spectrum.
Mhm.
And how do you create accommodations both during the interview process as well as during the job? And this becomes a really key part, not just about the minimum requirements that you as a company have to obligate, but it's also an opportunity to reflect the kind of culture of inclusivity and accessibility that your company is trying to promote, by actively stating the accommodations that you might make for candidates across different backgrounds.
Absolutely. And I'm a big proponent of, over complying or being transparent even where the law doesn't require it. Putting statements in your job posts that say we'll make reasonable accommodations, during the hiring process. And most employers aren't going to do the analysis of, is this person covered under the ADA? They want to be inclusive. So if it's some sort of neurodivergence that's not covered by the ADA, ultimately, I think the employer is going to figure out a way to even accommodate that request,
Yeah,
because they want to be inclusive. And they're
that's
not
right.
really, they're not going to reach out to me and say, hey, is this specific situation that a candidate has asked for, are they covered by the ADA? The easier thing is just to help them interview, help them get through the process. And you don't have to call a lawyer to do that. That's what you want to be and do as a company. And I think that being more proactive, more transparent, more inclusive, it gets you a long way towards legal compliance, but it's also an opportunity to show who you are as an employer.
That's right. Well, moving on. The next is the Age Discrimination in Employment Act. And as it seems to indicate, it's about avoiding ageism in your employment process, but also specifically in your job descriptions. Now, this has been a real problem, Renee, right? I mean, at companies, and that's why we've got this act, is how do we avoid age discrimination? And I just see this so often, Bill. It's one of the biggest areas of lack of compliance, right? I still see asking seasoned professionals to apply, asking for young and dynamic, recent college graduates. Does that expose, and what is the risk and harm here?
Yeah, I mean, I think word choice is important. If we're talking about the ADA, I see those types of language all the time. And is an employer going to get sued for having that in their job description? It's becoming more likely. I used to say no
Yeah,
way. It's really hard to prove discrimination in the hiring context. I used to say that, there's no way that an employer is going to get sued for having language like this. But now, I've changed my tune on that. I really do think that phrases like this, and if talking about the ADA as well, phrases like high energy or where is that really what you need, or do you just need someone to be productive? And so I think word choice is key, and I think that you could be excluding people from applying in the first instance, which you don't really want to do as an employer because you want a big pool of candidates to choose from. And you could be exposing yourself to legal risks. So say someone who is older or who does have a disability applies for your role, and you have language like this in your job post, and they either get denied outright, they can't, they don't even get an interview, or they make it through the interview process, and then the recruiter or the hiring manager realizes that they're older or they may have a disability, and makes a decision based on that and chooses the younger or the more the younger candidate, then you do
Yeah.
have a problem, especially if that person gets pretty, the disabled person or the older person gets pretty far in your hiring
Yeah.
process. They don't get the job, and then they see on LinkedIn, that the employer hired, the younger, more able-bodied person. Then you can get into trouble. You
Yeah.
can certainly be on the receiving end of a demand letter and potentially a lawsuit. And so, while it seems, may seem silly to really think through your word choice, again, legal requirements and branding opportunity, they go hand in hand when we talk about the job post.
That's right. Moving on to the EEO. Now, a lot of times, this is a conflation of sort of EO is a big umbrella law that
Yep.
talks about fair employment practices. But sometimes you think about it just as the EO statement at the end of a job that is a commitment to fair hiring, but it's different. Tell us a little bit about the EO in general and how do companies comply with the EO?
Sure. So you're right. The EEO laws or the term EEO is kind of an umbrella. And then all these specific laws sit under that, including the ADA and the ADEA, which we just talked about. Other EEO laws are, Title VII of the Civil Rights Act, which prohibits discrimination based on race, color, religion, national origin, and sex. You've got the Pregnancy Discrimination Act, Equal Pay Act, Genetic Information and Non-Discrimination Act, and that's not even all of them. But
Yeah.
so basically, at the end of the day, you're right. It's about fair employment practices, and it's about non-discrimination. A lot, that's what most of them are getting at. Non-discrimination because of a certain characteristic that you have, and these vary by federal, state, and local in the U.S.
Yeah.
And so obviously you want to be complying with all of those laws, and the way that employers signal that they are complying with those laws is these EEO statements. They're not required. Sometimes you read them and they're very heavy and have a lot of legalese, and you think, oh, some lawyer must have told this company that EEO statement needed to be in there. It's actually not required. I think most employers do it now as, proactive legal compliance to signal that they are trying to comply with the law. They are trying to comply with fair employment and non-discrimination. But again, also branding, back to it again.
Sure.
So this EEO statement that you have on here is an EEO statement I drafted for my most recent employer before I started my own practice. And it's informal, so it's not one of the ones with all that dense legalese. And we actually had candidates tell us that they read the EEO statement and that they applied just because of that, or that it made them want to apply more because this is a way that you're talking directly to a candidate and telling them, yes, we comply with these laws, but
Yeah.
we see them as the floor, not the ceiling. And so there are ways to draft these that are, compelling to candidates and again, branding, all about branding, all
Sure.
about inclusivity, I think is where a lot of these are coming from now. So I think it's weird if you see a job post that doesn't have one of these, but most people probably don't realize they're not required or, where these started to come from.
And there's a good reason to have them. In fact, Data People, we ran a study about jobs that had different types of EO statements and didn't have the EO statements. And we powered it with thousands and thousands of candidates to really understand how do candidates of different backgrounds react to EO statements. One thing we found is, by and large, candidate response was much when there was an EO statement than when there wasn't. And this was not only in the US, but even in international geographies where EO wasn't a mandated requirement, wasn't the umbrella of the EO Commission. And the other thing we found was that the way you frame the EO is important. Although you can choose to have it be really informal to formal, but specifically calling out that you are an equal opportunity employer was much more powerful than merely stating that you are committed to diversity.
Right.
But there's using the force of the law made candidates, especially those from historically underrepresented backgrounds, feel like they were more likely to get a fair shot in the hiring process. Now, a big part of it is making sure that you follow through on that commitment in the way
Right.
you hire. It's more than just the words you put on your job post. But let's move on. Let's talk a little bit about FLSA. Now, Renee, when you started out, you said FLSA is one of the ones that causes a lot of stress. It's a very mechanical, manual approach to comply and can also result in very large class action lawsuits and result in millions of dollars of losses for companies. How do companies think about FLSA and how do they go about sort of complying with it?
Sure. So we could do an entire webinar on wage hour laws. So, I think that the key is to get classification right from the beginning. Ideally, classification is being handled centrally by HR, not by TA, not by the hiring manager. HR professionals who may or may not be working with legal counsel on the back end tend to know a little bit more about, whether someone is exempt or non-exempt. Exempt generally means salaried, non-exempt generally means hourly. There are exceptions to that we won't get into here, but it's difficult to make these determinations. Most hiring managers don't want someone who's hourly. They don't want to deal with time tracking. They don't want to have to pay overtime. So if you ask a manager whether they want this role to be exempt or non-exempt, 9 times out of 10, they're going to say exempt because they don't want to, have to, approve time cards and things like that. So you really don't want these classification decisions to be in the hands of hiring managers or TA. You really want HR to be doing these on the back end, ideally hard coding it into the HRIS system. So the decision is already made, that it can't be changed. This role at this company is non-exempt. And it always will be across the board because, when you start to get inconsistent within your company of, this role is exempt in Arizona, but in California, it's non-exempt. That's when you can be signaling, to employees in that role that, maybe you've got one group of them misclassified in some way. And it's really hard once you've classified someone and hired them. Changing someone from non-exempt to exempt, that's easy. But going from exempt to non-exempt, it's complicated because then you have to figure out, what do we do about back pay? We don't know how many hours of overtime they've worked. Do we just make the change here going forward? But we probably have liability for that period from when they started to now. And so it's, from a legal perspective, complicated to figure out how to make the change. I mean, you want to make it, but let's be clear. But there's a lot of decisions that go into that. So I'm a big proponent of training HR, make sure they understand classifications. If they're on the fence, make it non-exempt. Basically hard code it as much as you can in your HRIS and ATS systems.
And one of the complexities always is that, at the end of the day, the difference between the job description and the job post. HR controls the job description, that's often in the HRIS. A hiring manager or the TA team might write the job post, which is in the ATS. Unfortunately, in a lot of situations, the ATS and the HRIS don't talk well with each other. And this is where we can run into problems. We can run into problems where we classify a role one way, but end up accidentally writing the job post another way. And this is where compliance software can be really helpful, or compliance checks can be really helpful, making sure that ultimately all of these pieces are working in the right coordination. So sloppiness or mistakes don't set you back as an organization.
Right. And I often work with or have worked at organizations where obviously they want to make as many roles exempt as possible, but there have to be non-exempt roles at most companies. They're just do. And so if you're at a company and everyone in your org is exempt, I'm here to tell you that you're probably not complying with the law. And there's nothing wrong with being non-exempt. It's just it's maybe someone early in their career, or it's an entry-level role. Like there's no issue with that. There's no stigma.
Yeah.
Oftentimes you just kind of see um, you know, organizations just wanting everyone to be exempt because they don't want to deal with the time cards and the overtime and things like that. But there are people who support the organization in administrative ways, and so you really need to think critically about which roles there are. Oftentimes they're in marketing, HR, TA, QA, if you're talking about tech companies. And so you have to have non-exempt employees at your company, as far as I'm
That's right.
concerned.
So now let's move to the other really big one, pay transparency. And this is taking the world by storm. It
Yep.
started off, at least in the US, it started off with Colorado a few years ago, launching its pay transparency laws. And then once California adopted it and New York adopted it, it became pretty widespread. And now every state's adopting it.
Yep.
Not only that, it's created some confusion. For example, different states define it differently. New
Mhm.
York recently clarified that it has to be a good faith range. You can't just put $0 to $500,000
Yeah.
and get away with it. They've been fairly aggressive about finding companies around that. We've also seen very specific, we've seen different geographies internationally start to adopt it, both in Canada and in Europe, different provinces. So this is in a distributed hiring world, this creates a lot of stress
It does.
because it creates the processes. You've got to get it right. And you got to also make sure it can also create internal stress if you put out a pay range that doesn't align with your leveling framework or where employees are getting paid currently for similar roles. It can create pay equity issues.
Yes.
And so you're seeing a whole range of issues. How do companies sort of think about if you're a global employer today, how do you think about pay transparency? Like, do you just try to comply with the most stringent law that you might be hiring in? So if you're hiring in California or Washington State, you want to, and even if you're posting jobs in other states, you just want to try to stick to a consistent national view or international view of the world?
Yeah, so it's a great question. And when these laws first started coming out, I was in a legal only role at one of the companies I was working for, and my initial reaction was, what a pain these are to comply with. But then when I got into chief people officer, head of HR roles, I actually had a different perspective that these are great.
Is that
Um,
great?
they're great. They're setting expectations. No one's wasting time. I mean, one of the points I have here on the slides is candidates don't want to waste their time interviewing for a role that doesn't meet their compensation and benefits needs. And do you as a company want to be wasting your time interviewing candidates who you get to the end of the process and you make them an offer and that the pay is not what they expected, and you have to go back to the drawing board or reach out to a different candidate? Like, I actually think this is great for candidates and employers. And so, what I advise my clients to do is just provide it proactively, provide pay ranges, provide basic benefits information. You don't have to, put every last benefit that you offer, but provide the basics. And then I think it's less important whether this pay transparency law applies and this one, and how do they
Mhm.
define compensation, because you're complying with the spirit of all of those laws. And
That's right.
so regulators, states, agencies that are enforcing these laws, they're looking at the employers who aren't complying at all. So if you
That's right.
have some sort of pay range, some sort of transparency about benefits, for the
Mhm.
most part, the regulators aren't really going to pay attention to you. They're more looking for either the companies that aren't complying at all, or they're putting that $0 to $500,000 pay range. And so as long as you're, trying to comply with the spirit of all of these laws,
Yeah.
regardless of where you are, I think you're in good shape from a legal perspective and also from a branding perspective. I think candidates now really want to see that on job
That's right.
posts. And when
Yeah.
you don't, you're like, the first question they ask the recruiter is what's the pay range? And so why not just
Yeah.
put it up there anyway? And I think it's really helpful for everyone if companies start doing that.
This also has a huge impact on recruitment marketing and employer brand because increasingly the job search engines like LinkedIn and Indeed not only are mandating that you provide pay transparency in the jurisdictions that require it, they also are very prescriptive about the format in which you provide that information. So you can't just choose your own custom format. You have to have minimum and a
Yep.
maximum range. And those are areas where data people can help immensely because we can localize to your location of the job. We can localize to the types of places that you're posting your job in and making sure you're complying with those as well. I want to talk a little bit about some of the other different regulations coming up that might not typically be associated with job descriptions or with hiring, but they are important, like the CCPA in California or the GDPR in Europe.
Yep.
The privacy requirements that are increasingly impacting candidates just as much as they impact consumers. How do companies sort of bake this into the ATS, and this defines the choice of the ATS, Renee?
Sure. So, a lot of these privacy laws, you just think to yourself, this is, aimed at consumers who are buying some sort of product online, whether it's e-commerce or, SaaS platform. But a lot of them have requirements that apply to employers. And
Yeah.
so, you know, beyond the scope of this webinar for sure, but ultimately what a lot of them require is disclosure and transparency about what types of data you're collecting, why you're collecting it, how you're using it, if you're selling it. And that piece should be in your overall privacy policy that does apply to consumers,
Yeah.
or you can kind of carve it out and just put it in your ATS or on your your hiring page on your company website. But basically, you again coming back to transparency, telling candidates how you're using their data. And in the case of California, you have to have a mechanism where they can request that you delete their data. If you're a candidate, you've applied to hundreds of jobs and your data is sitting in a bunch of different ATS systems at different companies, you may not want your data floating out there. And so,
Yeah.
in California, you as a California resident can request that data be deleted. And so, again, linking to the privacy policy is the best way to comply with this. But always also making sure your privacy policy, covers this employment context rather than, just the consumer context.
And many ATSs and HRISs have different sort of standards when it comes to this. And so this is, as you pick the right vendors to work with, these become really important questions to think about. How do they operationalize this? They're all compliant with it, but how do they operationalize it? And is that in a way that fits your workflow and fits the way you like to sort of approach your consumers and your stakeholders?
Yeah, and it is nice to know that the levers and the greenhouses of the world are, they're building in compliance solutions for things like this to make it easy. It doesn't get you 100% of the way there, but they are making it easier for you once you do have, kind of your privacy policy in place.
That's exactly right. Now we turn to AI. And my goodness, this is a confusing thing. It's all we hear about. It's AI everywhere. But we're starting to also hear about AI regulation. And it's catching up. It's really early. We're seeing it in New York City. We're seeing it in Colorado, where we're thinking about how we use algorithmic means in the hiring process. And then in the EU, it isn't passed yet, but there is a proposed EU AI Act that is much broader. I'm curious, Renee, as you think about how companies approach AI, how should they stay abreast with these regulations? Because sometimes these are really broad.
Yeah, yeah. It is kind of the Wild West with these regulations and similar to the privacy regulations we just talked about, none of them are the same. They have different definitions, different coverage. early indicators of these AI regulations are what the regulators seem to care about are decisions that are being made by AI without human oversight. And so I think best practice, until there are more of these laws, or until, we kind of understand where they're heading, is if you are making decisions using AI in the hiring process and there is no human oversight, there's not a TA professional in the building looking at this stuff. I think that's when you really need to start to think about disclosure and being transparent about that with candidates, even if you're not required to, because that seems to be where these regulations are heading, is when we have the AI literally doing the work and making the decisions. That's where regulators are starting to become increasingly concerned.
That's right. And disclosure is important. It might just be, again, a link or a small amount of text in your job post that articulates that you use certain tooling or that you might use certain tooling, but it's important that candidates know how you approach this process. And actually, we recommend companies talk about how they hire on their company blog. I mean, it's such an important piece of employer. It goes a huge way in employer branding. It goes a huge way to also helping candidates prepare effectively for your hiring processes. And so provide them the information about how you hire. And if you're using AI in there, be transparent to the degree that you can be about the types of tooling that you use and why you use it and how you use it.
Yeah, I agree. And I think that I don't think the solution is to not use AI in the hiring process, because that's clearly where we're heading, especially in down economies where you can get tens of thousands of applications for one job post. The only realistic way to go through some of this stuff is using an algorithm, which, may or may not be AI, or incorporating AI, to help narrow down the candidate pool. Just because you may not have enough resources to sift through all of those. And right now in the ATS, a lot of times it's keyword searches, or, trying to find the needle in the haystack of all those applications. But, I do think employers will increasingly use AI to help them sift through all of those applications. And so I don't think the answer is to say, we're never going to use AI. Realistically, that's where we're heading. And so if you do use AI, have human level review, have some sort of simple disclosure, even if it's as simple as we get thousands of, applicants for every job we post, we use AI to help filter through some of those applications to narrow the applicant pool, something like that. It doesn't have to be scary, big brother, robots, all that type of stuff. It's just again, going back to branding and transparency, I think that gets you a long way towards compliance, and it actually, I think, helps with your candidate experience as well.
That's exactly right. Well, let's talk a little bit about there's, we talked a little bit about hiring compliance. There's recent regulations have been sort of expanding this hiring practices. There've been public infractions that you've probably heard about, whether it's some of the big news articles, but also the fact that different from pay transparency perspective, both Washington State, New York State, and New York City have been more aggressive about fining and creating lawsuits against companies that have violated and not been complying with their laws in good faith. Yep. And then, of course, it's just making sure you're avoiding scrutiny, driving best practices. And it's impossible for a TA or HR professional to be a legal expert in every one of these realms. What's important is standardization and putting the right frameworks in place. So you're making the right choices as an organization and then following through on them in the actual workflow of the way you write your job posts, the way you comply with these. Beyond compliance, there's also at the regulatory level, there's a whole lot of internal standards that you've got to pay. Companies think a lot about employer brand and employer brand compliance, your voice and tone, your own hiring guidelines. Increasingly, whether you have a DE&I or inclusivity mandate that's from your company, Some companies and organizations are mandated either through OFCCP regulation, which requires a certain amount of, requires government contractors to hire fairly and show a commitment of hiring fairly, but also, healthcare regulators and different regulators across the country and globally are increasingly mandating a commitment to diversity and fair hiring in your hiring process. And so those are all things to consider as you think about the gamut of standardization and the gamut of compliance.
Agreed. And I would just add, there used to be a day where your comms department only dealt with external facing comms to investors and consumers, but more and more I'm seeing, comms departments have dedicated resources to employee comms and candidate comms. And I think it's really important to have that voice and tone and consistency across the org. If you have the luxury of having the ability to hire that role, I think it's really important.
And I think that's a great point. I mean, a lot of times comms used to be all about sort of your commercial message, not about your employer brand. But today, if you're a non-consumer company, a B2B company, a SaaS company, chances are your job descriptions get seen a lot more across LinkedIn, Indeed, and all of these channels than even your corporate website. And we spend hours finessing every pixel on the corporate website and not enough time thinking about the job description and where that takes us. And it surprises us sometimes when a really poorly written job description puts us in the news media, the crosshairs of, an angry online mob, because we didn't take the care of duty to communicate our values fairly and correctly through our job description. And that's what we're here to do.
Yep.
One of the things that's important is how do we think about solutions in education? That's why we're here today. It's about building a truly integrated compliance program. It's not about just being, there's one method, which is to be reactive. And Renee spoke a little bit about that. Sometimes we're just sort of reacting to laws, reacting to things coming about, reacting to complaints. That's maybe okay for some companies, but increasingly in a global environment, that is hugely risky. The step up from there is proactive reporting, checking, monitoring, training. But then really what companies should be aspiring to do is standardizing and instrumentation. Make sure your processes are so well standardized so that your chances of failure and chances of risk are low. And then you don't have to keep revisiting it. It also takes a lot of cognitive load off of your TA and HR teams, because the last thing your TA and HR team is going to do is just get consumed in the world of compliance. You hired them to take care of talent, to hire, upskill, up level, and create a great employee culture. Last thing you want to do is burden them with the manual work of constantly worrying about the regulatory framework that's evolving and how do we build that. Now, Renee, you've been an HR leader. And when you think about like the balance of time, how do you think about making sure your talent teams are actually focused on talent?
Yeah, I mean, I think to your point, if you put the processes in place and you've standardized all of them, your TA team shouldn't really be thinking a lot about compliance. You don't really want them to be kept up at night over compliance. You want them to be kept up at night over, am I going to be able to close this amazing candidate we want to bring to the company? And so kind of like we talked about with the wage and hour laws, hard coding things into your HRIS and ATS, anything that you can standardize and put a process in place so it's just everyone knows they need to follow that, and they know by following that they're complying with whatever law, then I think that allows them to just focus on their job, which is bringing talent to the company.
That makes a lot of sense. So a little bit about data people. What data people does is we come in after you've spoken to someone like Renee, where which laws really you need to be compliant with, the frameworks you need to put in place, the standards you need to put in place. What data people helps you do is scale that and make sure that you're compliant and you're systematically thinking about your job descriptions and your talent acquisition processes without having to worry about it. Whether it's comprehensive coverage in terms of DE&I, individual state by state, city by city law and regulation, and employer brand. It's integrated with whichever ATS system you use. It has workflows and templating built in and has embedded upskilling. And our goal is ultimately to up-level you. Now, we can't do everything. And every now and then you might run into situations where you need to work with Renee, where you need to work with Employment Counsel. Renee, when do you like to be called by companies thinking about, how to use or how to think about compliance?
Yeah, so I mean, I think one of the main reasons people reach out to me in the hiring compliance space is trying to figure out if a certain law applies to them at all, because of their size or because of where they're located or because of how the law is drafted or what the definitions are. So that's always a good time to reach out to counsel. And I think someone like me who's been in HR roles and legal roles and compliance roles, I can also help put some of those processes in place so that your TA team is not thinking about compliance really in their day-to-day. It's taken care of for them. A lot of lawyers don't even know what HRIS or ATS stands for, but I've been kind of hands-on with those types of platforms and can help set up those processes. So so that compliance is kind of already taken care of and on autopilot, and so that folks can focus on the more important stuff.
Fantastic. That's exactly right. So what we do in Data People is then help you measure it, monitor your exposure, prevent issues, alert you and surface up where issues might happen so that you can deal with them right away. They're not lingering on your website. You're not waiting for candidates to tell you that you're not compliant or waiting for, God forbid, a lawsuit or a complaint. We're getting ahead of these situations every day. We work in 80 countries around the world. We work with some of the world's leading brands. We're systematically used, and we become part of your workflow. That's us, the Data People. We want to help you here stay compliant and stay focused on what you're here to do, which is win great candidates over to build incredible businesses that you do every day. Renee, thank you so much for joining me on this incredible time and incredible webinar. I learned a lot. I
Thank you.
really
It was a lot of
appreciate
fun.
you
A
sharing
lot
your
of fun
business.
chatting. I appreciate you having me.
Absolutely. All right, everyone. Thank you for joining us today and have a wonderful week.